Hello and welcome back to Attorney Paz's Rants of a Criminal Defense Attorney. Today I want to discuss the burdens of proof across the legal spectrum and which apply in which situations. So to do this, I'm going to refer to my handy dandy spectrum of burdens of proof. I made this myself, and this outlines pretty easily the different types of burdens that are applied, but they are not applied in all circumstances or even in all areas of the law. So the term you all hear most often in criminal cases is beyond a reasonable doubt, which is all the way at the end there. And if you could see, it's something less than 100%. So when juries are instructed about beyond a reasonable doubt, they're going to be told that it's something less than 100%. It's something more than clear and convincing evidence, which is something that is applied in some types of criminal cases, like, for example, in a Fernando A hearing, the judge will often apply a clearing and convincing evidence standard. It's also most often applied in contract cases. Now, as you go towards the left after clear and convincing evidence is preponderance of the evidence. I tell clients that is almost exactly half. It's right over the halfway threshold. It's 50.1%. So basically what that means is it's more likely than not that this is the case, right? And so you could see how it's much, much lower than beyond a reasonable doubt. And so when I'm talking to clients about violation of probation hearings, this is where this becomes important. There's a reason, folks, why I tell people don't go to violation of probation hearings. And this is the reason why. It's because you're going to be in front of a judge, and the judge has to make a finding by a preponderance of the evidence that you violated your probation. Not beyond a reasonable doubt, closer to 100%. It doesn't have to be 100% or beyond reasonable doubt percent certain that you violated your probation. It's just 50.1%. Did you violate your probation? And so because there's such a drastic difference between what the state has to prove, it almost never ends well for clients. Now, as you go more towards the left is probable cause. Now, that's what is required to arrest you. So I get a lot of calls a lot of the time where they didn't have any reason to arrest me. They can't arrest me. My rights were violated. You'll read the warrant, and as long as there's some reason to believe that there was a crime committed and that you committed it, probable cause is going to be satisfied. If you've ever heard the saying that it is so easy to get an indictment, like in federal court, federal court, you can indict a ham sandwich. That's the reason why. It's the reason why is because probable cause is such a low burden of proof. You don't really need very much. So probable cause, if somebody really calls me and says there was no probable cause for my arrest, 99% of the time, that's not the case. And even less of a requirement is reasonable suspicion. This is what the police need to stop you to begin an investigation, right? So when they pull you over on the side of the highway and they start talking to you or investigating you or interrogating you, they really only need reasonable suspicion. And all that is they have to have an articulable reason that they have initiated this investigation, okay? It can't just be, there's a person walking around in a neighborhood where there's a high rate of crime. That's not articulable enough. You need to say, okay, well, I had a call that a person was walking around and looking into cars. And so now I'm driving in that area and I see a person matching that description. That will be reasonable suspicion to make the stop. Now, it hasn't moved along the line yet to probable cause to find out if he was trying to break in or if there were items missing. It hasn't escalated to that point, but it's enough to begin that investigation. Do you see how low that is? Do you see how little the police need to actually stop you to try to talk to you? It's minute. So in criminal court, we do use this whole spectrum. We do use all of these burdens. In civil cases, most of the burden is preponderance of the evidence. So when I talk to clients about, civil cases, and, you could very well have a civil lawsuit pending as a result of a criminal arrest and be not guilty in criminal court because the burden of proof is so much higher, but be liable in civil court. And that's exactly what happened to O.J. Simpson, by the way. Not to date myself, but essentially that's exactly what happened. He was found not guilty beyond a reasonable doubt in criminal court because they couldn't prove he did it beyond a reasonable doubt. But because the burden of proof was so much lower, he was found liable in civil court, and he owes Nicole Brown's family all that money. So I hope that this was helpful, and follow me for more.